Welcome everybody to the session on family law developments in Provincial Court. It's combined with another shorter session on COVID-19 support variations. We have a panel of 6 people from various ministries who I'll introduce shortly. Before we start though, I want to acknowledge that we are on the shared traditional unceded territories of the Musqueam, Squamish and Tsleil-Waututh people. They have stewarded these lands for many years, and we appreciate and acknowledge that and look to working together in the future in a respectful and positive manner. So let's start by introducing the panel. Because they have a lot of information and because there's a lot of them, I'm just going to give you the names and positions of each person. And then if you want to see a more full biography, you can look in the app, the SCED app. Okay, so, sorry, I'm just looking, there we go. Okay, so we've got the Honourable Judge Susan Wishart is the Associate Chief Judge of the Provincial Court. She has been working on changes in Provincial Court family rules and on new procedures in the courts in Victoria. Shannon Knudsen is our first presenter. She's legal counsel with the Family Policy, Legislation and Transformation Division. Erin Smith is a senior policy analyst with the same division or department. Oriole, Courcy and Christine Heaney are senior program policy analysts with the Family Justice Service divisions of the Ministry of the AG. And one speaker who's not on the screen yet, but will be coming later, and who I think has presented at conferences in the past, is Sandra Wolf. She's the Senior Director of Maintenance Enforcement and Locate Services with the Ministry of the AG. So that's my job done. I will hand it over to the speakers. As Kayla's just said in the chat, please remember to put your questions in the Q&A. That helps ministry people monitoring the questions and also gives us a record of the questions in case there's any that need following up. Okay, thank you very much. Shannon? You must be muted. No? Yes, you are. Just 1 second. That. Okay, she's not muted. Can you speak again?
Right, so it's Erin Smith here. Perhaps while Shannon's getting her audio sorted out, I'll just introduce you a bit to what we were planning on covering today. And perhaps if she's logged in, we can start with her introduction and then move on. Otherwise, we'll rearrange some stuff today. So the presentation today is titled Family Law Developments in Provincial Court. The presentation was intended to begin with a bit of an overview of the project to modernize the Provincial Court family rules. All of the panel members that are here today have been involved with this project over the past several years. In 2016, an overview of the Provincial Court Family Rules Reform Project was one of the agenda items for this conference. That was back in the early days of the project, and we appreciate the opportunity to return to this conference to share the progress the project has made over the past 4 years. So we're going to talk briefly about the background and the underlying objectives of the new model introduced in the new rules, and then describe the types of family law matters the new model applies to. We'll spend a bit of time explaining how parties navigate through these new processes. And then our plan was to have a brief 5-minute break around 3 p.m. and then return to discuss the new forms that the model introduces, describing the improvements to the forms that will make them easier for people to use. And then the second initiative we were going to talk about kind of flows from this that we might actually start with is the practice directive that the Provincial Court sorry, just following different notes here. The Provincial Court has introduced with respect to COVID-19 support variation, which was introduced to address people's need to suspend or change child or spousal support due to a COVID-related change in income. So our plan for the presentation today was to take questions at the end, in part because a lot of the different components we're covering will hopefully answer some of your questions as you go along. However, you're free to put any questions you have into the question and answer chat in the side panel, and we will address those as either throughout the presentation or at the end. If there are questions we don't get an opportunity to address, we will respond to those by email, or you can email them to the email address that's provided at the end of this presentation and should be in your slides you were provided. So checking in now to see if we've got Shannon with audio.
Okay, you can hear me now, Erin?
Yes.
Okay, so when the Family Law Act was implemented back in 2013, the Provincial Court family rules were amended to the extent that was needed to reflect things like the new terminology that was used in the Act, but there wasn't an opportunity at that time to do a comprehensive review. So the Ministry and Court agreed to undertake comprehensive review of the rules soon after the Family Law Act was implemented. In about 2014, a working group was convened that included Provincial Court judges, lawyers, a representative from a community organization, and some ministry representatives. There was some early engagement with various interested organizations throughout the project, and about a year ago there was a public consultation paper that was published. It included proposed draft language and forms. The policy recommendations that the draft rules were based on were developed building on years of research on how to improve the family justice system and the many recommendations that had been published in reports like that of the Family Justice Working Group of the National Action Committee on Access to Justice. The final version of the Provincial Court family rules incorporated the feedback that we received in response to the public consultation paper and the discussions that we had over the years with individuals and organizations who had experience with family matters in the Provincial Court. The complete new set of rules was approved by Cabinet in June of this year. It'll be implemented on May 17th next year, so 2021. The delay between the approval by Cabinet and the implementation date will allow time for training and for systems updates before the rules come into effect. In the meantime, however, some funding became available to support early implementation of certain aspects of the new rules, namely the early resolution and case management model in both Surrey and Victoria. So the new model, the early resolution and case management model, will be in effect in these locations as of December 7th. This builds on a prototype of the early resolution and case management model that's been operating in Victoria since May of 2019, so for about the last 18 months. The amendments to the existing Provincial Court family rules that become effective as of December 7th refine the model a bit based on the experience of the prototype in Victoria. It also more closely reflects the rules that will come into effect in May of 2021. The processes that will be in place in Surrey and Victoria as of December will continue on under the new Provincial Court family rules that come in May of next year. I do want to note that there's one division in the new rules that won't be implemented in May of 2021. There are rules in Part 9 that authorize an informal trial pilot project, which won't be implemented until the following year, in May of 2022, in one or more locations that are still being determined. Holding off on implementing the informal trial pilot rules will give all court locations time to become familiar with the new rules and processes before layering on an additional new process as a pilot project in one or a couple of locations. So, as I mentioned, the early resolution requirements are a key part of the reforms that are being introduced in the new rules. The early resolution model supports the aspirations that were articulated in the Family Law Act, namely to encourage families to resolve conflict other than through court intervention where appropriate. We know that families who approach the family justice system are dealing with more than just legal problems. About 82% report experiencing related health or social problems, in addition to their family law problems. The graphic that you see on the slide, which is taken from the Canadian Forum on Civil Justice, illustrates the tangled web of problems that are often interrelated with separation and divorce. Families going through separation and divorce often struggle with problems at work. Children struggle at school. They have housing issues as they try to change one household into two. Many families deal with physical illnesses and mental health problems or substance abuse. We know there's often a risk of increased family violence during separation and divorce. We also know that the way that families experience separation and divorce can have long-lasting consequences. The impacts affect not only the adults in relationships, but children in the family as well. In recent years, there has been a fairly well-documented brain science research on the impacts of living with.
Sorry.
Yes?
We're just having people say it's a little bit quiet. If you could, I hate to mess with the sound, but if you can.
No, that's okay. I'll try and move closer to the microphone.
Much better. Thanks.
Sorry. Researchers have found that adverse childhood experiences, which are traumatic events that children experience during the period before they become adults, can have long-term negative outcomes reaching into adulthood. Divorce is one of the 10 adverse childhood experiences that have been identified. The others include things like different types of abuse, neglect, and various household dysfunctions, including mental illness or having an incarcerated relative, living through family violence. The stress and conflict that parents deal with going through the family justice system also impacts children. And the court process, which addresses the legal problems children are facing, hasn't been as well equipped to support families with these other social problems. So why implement the early resolution model? If we look at the new rules, it articulates the objectives. The purpose of the early resolution and case management model is to encourage parties to resolve their cases by agreement, or to help them obtain a just and timely decision in a way that takes into account the impact the conduct of a case may have on a child and family, that minimizes conflict, that promotes cooperation between the parties, and that provides processes for resolution that are efficient and consistent with the complexity of the cases to be resolved. If we turn to the next slide, it contains a diagram that helps to explain how these objectives are achieved. Here we see how the early resolution process fits into the rest of the court processes. The early resolution process is depicted in the orange boxes on the left side of the slide. As I mentioned, this process will be operating in designated registries, which have added resources to support the model. The model is going to be introduced in Surrey on December 7th, and it's been operating as a prototype in Victoria since May of 2019. And we anticipate that more registries will be designated as additional funding becomes available. So this diagram that we're looking at is a high-level overview of the process, and we'll get into more of the details about the steps in the process as we continue through today's presentation. If you look at the red box, which is closer to the right-hand side of the slide, you'll see that it depicts protection orders and priority parenting matters being positioned directly above the trial or hearing. That's because these matters, protection orders and priority parenting matters, are often time-sensitive and need a decision without delay. So under the early resolution model, they do not go through the early resolution process. Rather, these particular applications proceed directly to a judge for decision. The early resolution process does apply to most other matters that are dealt with in provincial court. Parties begin with an individual needs assessment with a family justice counselor who refers the parties to supports and next steps in the process. Depending on the parties and their situation, those next steps might include legal advice, participation in consensual dispute resolution, parenting education, or a wide range of community-based referrals. The focus of the early resolution process is on early support, providing information and assisting families to resolve their issues before an application to court is made. If, however, after these steps, there are outstanding issues to resolve, then an application may be made by either party and a family management conference will be scheduled. In the diagram, that would be the parties moving into the blue box. The early resolution process has been designed to help families to reduce conflict and work towards an earlier, more collaborative resolution, keeping children's best interests front and center, rather than moving quickly to adversarial positions. The model being introduced builds on existing family justice services, including assessment, mediation, and parenting education. However, it makes the referral to those services earlier in the process, before the parties have completed and served an application for a court order. The model doesn't anticipate that all parties will resolve all of their issues in the early resolution process. Although many do, the process benefits all parties as it helps them to clarify and narrow their issues, even if they aren't fully resolved during the early resolution stage. One of the positive outcomes of the process is an increased readiness for court in those parties who do have outstanding issues. For parties seeking court order after completing the early resolution process, the Family Management Conference is the first step in court proceedings after the application process. The Family Management Conference in part replaces the notice of motion or family remand process that currently exists. It provides active case management and meaningful court appearances. Parties are helped to explore options for resolving the dispute or to ensure that the case will be ready for trial, with directions to next appropriate steps, and any interim or case management orders that might be needed. The final stage in the process for some parties would be a trial. Even now, a relatively small percentage of cases proceed all the way to trial. The early resolution and case management model is intended to support more families to resolve their matters before reaching a trial stage, and to help those families who do go to trial to be better prepared and to have their issues narrowed before they require a judge to decide them.
Hello, I'm Erin Smith. I'm a Senior Policy Analyst with the Family Legislation Policy and Transformation Division. So I was part of the working group that developed the new rules and have been part of the team leading the operationalization of the rules, both through the prototype in Victoria and now the implementation of the model in both Victoria and Surrey, as well as the broader province-wide implementation. Together with Oriole, Courcy and Associate Chief Judge Wishart from the Provincial Court, who have also been leading the operationalization and implementation, we're going to take you through various processes under these rules in the next part of the presentation. So the Provincial Court family rules apply to cases in the Provincial Court about matters under the Family Law Act and the Family Maintenance Enforcement Act. The early resolution and case management process applies specifically to orders about the following. So family law matters are a new defined term that includes parenting arrangements, including parental responsibilities and parenting time, child support, contact with a child, guardianship of a child, and spousal support. The early resolution requirements apply to a party seeking resolution of a family law matter in Surrey or Victoria. Priority parenting matters are another new defined term under these rules. Priority parenting matters are a defined list of issues that arise with respect to a child that require resolution through a time-sensitive court order. They are generally decisions about a child where all guardians are not in agreement and are time-sensitive, such as medical treatment or non-removal from a geographic location. Applications about priority parenting matters are not required to meet the early resolution requirements. However, if an order about a family law matter is required subsequent to obtaining an order about the priority parenting matter, a party must proceed through the early resolution process. For example, if you receive an order to prevent the removal of a child from a geographic location, but now you need an order about parental responsibilities. Protection orders under Part 9 of the Family Law Act. Case management orders, which are administrative or procedural orders that may be required throughout the course of a case. So they can be made by a judge at a court appearance without an application, but also on application by any party. Relocation is specific in this instance to applications under Section 69 of the Family Law Act to prohibit the relocation of a child where there is an order or agreement about parenting arrangements already in place. And then enforcement, which is generally enforcement under the Family Law Act of both court orders and written agreements or determinations that are filed with the court for enforcement purposes. So starting with a deeper dive here into the application about a protection order. So Family Justice Services Division staff at the Justice Access Centre are always available to assist a party filing an application about a protection order. Though there is no requirement to meet with a family justice counsellor about a protection order, FJSD staff provide valuable services and can help a person with the legal information to complete the court form, as well as making referrals to legal advice and community resources to support them. The application about a protection order is used to apply for a new protection order or to change or terminate an existing protection order. Depending on what the person is applying for, a different schedule will be completed. So the schedule to apply for a protection order is a guided affidavit, so no additional forms are required. To proceed with notice or without notice, a party needs to indicate their selection on the form. No additional notice of motion or application is needed if they are proceeding without notice. They will provide their reasons in the provided field. If the application is made without notice, the application will proceed directly to the court appearance, as in the normal course of scheduling, where they're usually heard the same day, usually within a matter of hours. If a party has outstanding family law matters, they'll be referred to the early resolution process following a decision on the protection order. The early resolution process, again, does not apply to the application about a protection order. If a party is proceeding with notice, the other party is served with a copy of the application, giving 7 days notice of the date for the court appearance. Proof of service is provided using a certificate of service. This replaces the affidavit of personal service to make it easier for someone serving a document to prepare the proof of service for filing. A new form introduced under the rules is the written response to application. This form is optional. A person replying to an application must attend court, but may choose to file the written response as well. At the court appearance, a judge will make an appropriate order based on the information and evidence they are provided. The schedule for applying for a protection order helps to guide both the applying party and the court through the circumstances that may warrant different terms being part of the protection order, including weapons restrictions, communication for specific purposes, and police assistance to supervise the removal of belongings. As is the current process, the protection order registry is notified by the court registry of any protection order, change to a protection order, or termination of a protection order. Police have 24/7 access to the protection order registry in order to confirm the status and terms of a protection order. There have been changes included in the rules with respect to the drafting of protection orders to assist with enforcement. If any terms of a protection order are changed, the judge must terminate the existing protection order and issue a new protection order with all the applicable terms, including any new terms. In this instance, and with the termination of a protection order, a distinct order is drafted that clearly terminates the old protection order, so that it's clear to everyone what needs to be followed. Registry staff will also be continuing to facilitate service of a protection order on a restrained party who is not present in court if they're located in BC. Where the registry staff are unable to facilitate service, either because there's a lack of information about the whereabouts of a person or they're evading service, the applicant can request an order for an alternate method of service to help facilitate that. Priority parenting matters, as we said, are a defined term under the rules. Generally, there are these decisions about a child where all guardians are not in agreement, and a court order is needed about the priority parenting matter before any other parenting issues can be addressed, or separately from any other parenting issues, usually because something must be done quickly. Again, such as a decision about medical treatment for a child or non-removal of a child from a geographic location. The early resolution requirements do not apply to an application about a priority parenting matter. However, again, FJSD staff are available to assist parties with legal information to complete the form, as well as referrals to legal advice and other community service providers. The application about a priority parenting matter replaces in part the notice of motion. Similarly, it requires service with 7 days notice of the court appearance. If the application is time sensitive or other special circumstances exist, the application can be made with less than 7 days notice or without notice with the permission of the court. So at this point, the question mark delineates that decision for the party as to whether they need to proceed without notice or without notice. Permission is obtained by filing an application for case management order without notice or attendance and is reviewed as a desk order. So if the judge approves the application, it will proceed based on their direction to the court appearance. If a party has outstanding family matters, they will again be referred to the early resolution process following a decision on the priority parenting matter. Once again, the written response to application form is available for a party that wishes to file a reply to the application. So moving into family law matters. So again, as we said, the family law matters is a defined term that includes parenting arrangements, child support, contact with a child, guardianship of a child, and spousal support. The notice to resolve a family law matter is a new form that is the initiating documents for parties seeking resolution of a family law matter. The notice differs from an application to obtain an order as it identifies the parties, but prompts the referral to the early needs assessment and CDR process before a party has asserted any positions or arguments. This approach was taken in order to avoid setting the parties into an adversarial mindset from the beginning of the process. The filing of the notice and referral to the early resolution process is required for parties starting to resolve issues about a family law matter, but also where an existing agreement or court order about a family law matter needs to be changed, canceled, or set aside. After filing the notice to resolve a family law matter, the party is required to provide a copy to the other party. The normal rules of service do not apply to the document. It can be served by almost any means of communication, including email, text, social media, etc. Upon filing, the party will be referred to the Justice Access Centre to begin the early resolution process.
Great, thanks, Erin. So I'm Oriole Courcy, as was mentioned. I have the pleasure of joining you from Victoria. Oh, sorry, I'm getting a little pop-up here. From Victoria today. So we have the honor of living, learning, and working on the traditional and unceded territories of the WSÁNEĆ and Lekwungen speaking people of the Esquimalt, Songhees, and WSÁNEĆ First Nations. Also, before I start, just want to acknowledge the traditional territories that each of you are joining us from today. I'm the Program and Policy Analyst with Family Justice Services Division, and as Erin mentioned, have been leading and contributing to the work of implementing the early resolution and case management model in both Victoria and now in Surrey. So in the following slides, I'm going to talk to you a little bit about the early resolution process and how parties are engaging with the Justice Access Centres as they navigate the early resolution requirements. Before I do that, though, I will just mention that the Justice Access Centres and Family Justice Centres around the province continue to provide services to individuals who are looking for assistance who've not engaged with the court or initiated any court proceedings. So those services are still available. So the early resolution process includes or introduces 3 early resolution requirements. The needs assessment, a parenting education course, which is otherwise known as the parenting after separation courses, and if determined to be appropriate, 1 consensual dispute resolution session. So as noted in the previous slide, that notice is to resolve initiates the early resolution process. So a party that's filed or received a notice to resolve document can contact the Justice Access Centre at any time. And at their first point of contact, they'll have an opportunity to talk to someone immediately to assist them in identifying their initial needs. So this would include a high-level immediate safety screening, early legal information, and an opportunity to receive relevant referrals to legal advice and community service organizations that might be helpful prior to attending their needs assessment. And at that time, they'd be scheduling an individual needs assessment appointment with a family justice counselor. At the moment, all those needs assessment appointments are occurring virtually through video and conferencing and telephone, but at some point, we'll be back providing in-person services in our local offices. So prior to attending, they're provided information about the assessment appointment so that they're prepared and know what to expect. They're provided the assessment questionnaire, which they complete on their own, and then they can return prior to their appointment, when they'll have an opportunity to review and discuss with the family justice counselor all the responses to those questions during their time together. The assessment questionnaire is the same standardized tool that Family Justice Services Division uses throughout the province. The assessment covers a variety of issues, such as screening for safety and family violence, mental health and substance misuse, discussions around communication and conflict, impacts of the dynamics of the family on the children, and support systems and finances. All of the information discussed in these assessments with all the parties provides the family justice counselor with the information that will assist them in making that determination about the appropriateness of consensual dispute resolution requirements. So that assessment interview is an opportunity for the party to discuss the dynamics of their family, for the family justice counselor to be able to support the family in articulating what issues they're hoping to resolve. The family justice counselor is there to provide legal information about the issues, as well as information about the early resolution and case management model. So during that assessment, the family justice counselor might also identify community resources that might be helpful, refer the party to online parenting after separation courses, and refer them for legal advice. So if child or spousal support is identified as an issue, they'll also advise them at that point of the financial documentation that's required to deal with those issues. And it's been our experience that the assessment interview provides an opportunity for full or partial resolution of the issues as they're working to define them, and provides the parties with increased readiness overall for whatever the next steps are in the process for them. So following the needs assessment with the party who's initiated contact with the Family Justice Centre, the Family Justice Council would then reach out to the other party or parties, if there's more than two, in writing, and invite them to complete the needs assessment. So they're provided the same opportunity as that initiating party to meet one-on-one with the Family Justice Counselor to discuss their perspective, completing the assessment process to screen for the same dynamics mentioned previously, so like safety and family violence, and assist them in clarifying or identifying what issues they might like resolved, what resources and referrals would be useful to them, and an opportunity to find out about where they could seek legal advice. So similar to the initiating party, if child or spousal support is identified as an issue, they would also be advised of the financial documentation that will be required to deal with those issues. And following the assessment or the second or subsequent parties, there's that opportunity for full or partial resolution or increased readiness to move forward. So our experience so far in Victoria, since we implemented 18 months ago, is that there really has been an increase in the engagement of those second parties in the assessment process from what we may have seen in existing Rule 5 sites where only one party is actually required by the rules to complete an assessment. So that's been really encouraging. We've also seen that many parties who are not particularly enthusiastic about the early resolution requirements after their assessments were really positive about their experience. And in fact, we have a client survey conducted and the clients overwhelmingly agreed that assessment would be helpful to all parties with family law matters and that assessment should actually be required for all parties with these types of family law issues. Having said that, there are going to be parties who are unreachable or refuse to engage in the process. And the model was set up to provide opportunity for early resolution, but not to contribute to delay in decisions being made for children. So communications from the Family Justice Counselor to that second party provides information about the requirements as well as the potential consequences if they choose not to engage. So under this rule, the Family Justice Counselor will provide that information to the court so that that party hasn't engaged, and that would actually prevent them in filing reply to any applications made by the initiating party unless they've completed the early resolution requirements. So the Family Justice Counselor makes several attempts in writing and followed up by phone to contact the second party or parties and provide them a couple of weeks from the first communication to schedule their needs assessment. But if they're unable to reach them or the party refuses to engage in the process, the Family Justice Counselor then documents that and gets back to the initiating party to discuss next steps and assist them with court documents or ensuring that they have the information about where they can access legal advice if they want to proceed. So the next early resolution requirements is that completion of a parenting education course or a parenting after separation course. So I've added the links in there of how to access those. So both the online parenting after separation as well as an online parenting after separation for Indigenous families that was developed last year. There's actually a link there on this slide for the trailer for that, for those that were unfamiliar with that course. So the early resolution model still has exceptions for when a party might not need to complete the program. So the Justice Access Centre can provide exemptions for situations identified in the rules, such as if they completed it in the last 2 years, if they can't access the online course, if it's not available in a language that they're fluent, or they can't complete it due to literacy challenges. In those early resolution registries, so Victoria and Surrey, as of December, the party no longer needs to complete a form for that PAS exemption. They can simply discuss it with their Family Justice Counselor, and if it's appropriate and they're provided that exemption, that is documented for the court and along with the completion of their other early resolution requirements. So that brings us to the requirement of the consensual dispute resolution. And so the rule articulates that a participation in at least one consensual dispute resolution session unless the parties meet one of a couple of circumstances that are detailed. So one, that the parties can't access a consensual dispute resolution services. So that really reflects the intent not to require parties to incur costs to complete those requirements. So if all the issues that parties wish to resolve are out of the scope of the publicly funded services through Family Justice Services Division, so for example, if the only issue is to reduce or cancel child support arrears or income needs to be imputed, the parties aren't required to participate in consensual dispute resolution, though they may choose to proceed with CDR with a private professional after they hear about it as an option. But the Family Justice Counselor at that point would identify that, document their completion of the requirements, and they could proceed to court should they choose. The other provision for where CDR is not required is where the needs assessor or CDR professional determines that CDR is not appropriate. So following the completion of needs assessment with all parties, the Family Justice Counselor makes a determination about whether consensual dispute resolution is appropriate and whether parties are required to participate in that one session. So this decision is made based on all the information gleaned through the assessment process. And maybe that one party doesn't engage in assessment, so CDR is not possible. And maybe they've recently completed CDR, either with Family Justice Services or a private professional. So they've fulfilled the intent of the rule. And Family Justice Counselors and CDR professionals always consider the individual circumstances in each case and really work with the parties to see whether there are ways to design a process that will address the concerns that they might have. So maybe including advocates or support people, legal counsel, using a shuttle process where they aren't facilitating a joint session. So they have different tools that they might use to mitigate some of the issues that parties might raise through the assessment or pre-mediation process. There are circumstances where safety, family violence, power imbalance issues, or other capacity or barrier issues such as mental health or substance misuse, or even cognitive difficulties can't be mitigated in the design of the process. So that might make CDR inappropriate. So the needs assessor or CDR professionals are able to give an exemption when the strategies available aren't sufficient to address those things. It's also important to note that while an initial decision might be made that CDR is appropriate, just after the needs assessment, CDR professionals' obligations continue to assess for appropriateness of CDR throughout all services provided. So they're working with parties to make plans for safety and other dynamics prior to consensual dispute resolution, during the consensual dispute resolution process itself, and making any necessary plans for considerations that might apply after a CDR process has completed. So if concerns arise at any point during the process that make it inappropriate to continue, the CDR professional can terminate the process. And if the parties meet that exception for that requirement and don't have to complete the CDR session, the Family Justice Counselors would document that for the court, and the parties can receive support from the Justice Access Center to discuss next steps and get referrals to legal advice so they're prepared for the process. Where it's been determined that they must fulfill the CDR requirement, they're provided information about their options. So they could continue into a mediated process with that Family Justice Counselor. If child support or spousal support are their only issues, they could complete facilitated negotiation with a child support officer at the Justice Access Center. They could hire a private family mediator, or they could complete a collaborative family law process conducted in accordance with a collaborative participation agreement. So the Family Justice Counselors at the needs assessment can let them know what the options are for them, and then they can make a decision about what's best for their family. The rules do require that they provide their relevant financial information to the CDR professional if they're negotiating child or spousal support. And at the completion of CDR, they might have resolved all the issues, and that might be documented in a written agreement or a consent order or MOU, depending on their needs or wishes. And they're, of course, encouraged to seek independent legal advice on any arrangements they're documented prior to signing. So once all parties have completed all of the early resolution requirements that they need to, they're advised that if they do have outstanding issues and they want to proceed with a court application, they can request that the Justice Access Center forward confirmation of their completion of those requirements to the court registry, which we do electronically. And that enables them to be able to file their application. So either party who's completed the early resolution requirements can file the application regardless of who filed the notice to resolve. So the Justice Access staff can also assist with court forms and referring them to legal advice. And in the last 18 months in Victoria, we've seen many folks are completing the early resolution requirements and not needing or requesting any further steps. So only about half the cases where we received that notice to resolve have resulted in one of the parties requesting that we do send that confirmation of early resolution requirements on to the court to enable them to file. We've heard from the Justice Access staff in Victoria, they found that many clients who were not particularly enthusiastic about mediation have ended up reaching resolution through the process and being really grateful for the opportunity. And this, again, was echoed through that client survey I mentioned earlier. So respondents overwhelmingly agreed that CDR is helpful for families with family law issues. And that further to that, most responded that when it was determined to be appropriate, CDR should actually be required for all families with family law issues. So that really supports the model that we've implemented. So similar to the slides on the other requirements, you'll see here as well, there's that opportunity for full or partial resolution, as I mentioned, and there's increased readiness or preparedness for the next step in the process, whatever that might be for them.
So after the early resolution requirements have been met, so again, as Oriole said, that means a party has completed the requirements or is exempt from participation, or in the case of CDR, it's not appropriate. So any party may file an application about a family law matter to ask for a court order about any remaining family law matter issue. The application replaces both the application to obtain an order and application respecting existing orders or agreements under the current rules. It's used to apply for a new order about a family law matter or to change or cancel an existing order or written agreement about a family law matter. The form includes 10 different schedules depending on the family law matter and whether it is for a new order or an order to change an existing order or written agreement. A party only has to complete and file the schedules that apply to them. So along with the application, a party must file their financial statement as applicable for an application for an order about child support or spousal support. Additionally, if a party is applying for guardianship of a child, they must also file their consent and request to complete the record check for MCFD and the protection order registry that are required to support their guardianship affidavit. So this is to ensure that the party's application is complete as it prepares for court. The application must be served personally on the other parties. So where there wasn't formal service with the notice to resolve, the application does need to be served personally. A party who's unable to execute personal service can make an application to the court to allow an alternate method of service. Proof of service, again, is now provided by way of a certificate of service. This replaces the affidavit of personal service, which required the person who served the document to have the affidavit sworn or affirmed before a commissioner for taking affidavit. Upon receipt of an application, the other party has 30 days to file a reply. If the other party does not engage, we've got this little option here. The party who filed the application would submit their proof of service, and after 30 days, if no reply had been filed, they can proceed to scheduling their first appearance. So they can continue through court even when the other party does not file that reply. If the party does reply, they too are required to have met the early resolution requirements. If they're unable to meet the requirements or require more time to meet those requirements, they can apply to the court to the extent the time to file their reply or for permission to file their reply before complying with the early resolution requirements. In the reply, a party can agree with any of the orders the other party applied for, disagree and provide their reasons for their disagreement, as well as propose the order they believe that should be made by the court, or make a counter application for an order about a family law matter that the other party's application did not already include. The form for a reply is also designed with schedules. The first series of schedules match up with the application and are used where a party disagrees with the order the other party is asking for. The replying party only needs to complete the schedules that apply to their response. The second series of schedules, 10 to 20, are to be used for the counter application. They mirror the application, and again, only the applicable schedule for the counter application needs to be completed. The financial statement and any other supporting documents are also required to be filed by the party with their reply. This ensures that both parties have provided the supporting documents required for the court appearance to be meaningful. After filing the reply, the parties are referred to the judicial case manager to schedule their first appearance, the Family Management Conference. These first appearances are being scheduled with the judicial case manager to ensure both parties are available to attend so that the appearance can be meaningful.
Thank you, Erin. In case people have forgotten the introductions, my name is Sue Wishart, and I am an Associate Chief Judge with the Provincial Court. I live in Victoria. And I have been involved in the early resolution prototype that started in Victoria in May of 2019. And I'm also involved in the development of the similar process in Surrey. So with respect to the family management conferences, the philosophy behind these conferences follows on the work of the early resolution process, with the idea being to greater involvement of the parties in solving their issues, with decreased reliance on the adversarial aspect of a trial where possible, as we find that this leads to more lasting agreements between the parties. We wanted to have more meaningful court appearances. Historically, people are scheduled for a first appearance, and they may have several appearances before anything meaningful happens, because the parties need time to speak to lawyers, they need time to get their documents together, to speak with the other parties, and so they're having to come to court multiple times before anything meaningful happens. And part of that is also based on the reality of the number of files on a court list on any given day. There just is not enough time for the judge to spend with each of the matters to try to resolve the issues and get the parties to either a consent order or an interim order or on to the next step. The Family Management Conference is also designed to have the parties come to court once, and if matters aren't resolved, move them on to the next step without having, again, multiple court appearances. And the way that we've been able to make the Family Management Conferences a meaningful court appearances in Victoria is largely the result of the success of the early resolution process. The only way that we can spend more time with people is if there are fewer cases coming into court. And as you've heard from Oriole, the number of cases coming into the court has decreased by about half. This allows the judge at a family management conference to spend more time with the parties and more time trying to assist them in getting to a resolution, hearing from both sides and engaging with them more than they would be able to do in a typical court appearance. The other way that we've made these more meaningful appearances is the parties schedule the family management conference in accordance with their schedule. Normally, the court dictates when people are having their court appearance, regardless of whether or not it works for them, which often results in an adjournment. So by scheduling it with the parties' availability and their counsel's availability, when everybody comes to court, they are ready to go. These appearances are also made more meaningful by the fact that the work done through the Justice Access Centre narrows the issues to the point where we're not discussing 10 issues, we're discussing 1 or 2, only the ones where the parties truly cannot agree. The design of the family management conferences has also assisted with their success, in that instead of having the conference in a typical courtroom, and now I'm talking pre-pandemic, the family management conference would be held in a conference room with the judge, the parties, and their lawyers all sitting at the same table, which is much more conducive to a conversation and makes the parties feel that they're able to provide input and have a discussion than if they were in a typical courtroom setting where the lawyers often did most of the talking. Again, this results in people getting to a consent order or at least partial agreement, and if not, then they are able to move on to the next step. Many files resolve at a family management conference if the parties just need some assistance in resolving their matters. And some may wonder why it can resolve at this stage but doesn't resolve at mediation. I think it sometimes takes a judge who might ultimately be deciding issues in a trial to say, if this goes to trial, here's what's going to happen, or here's what I expect would happen. And that often forces people to think a little bit more closely about their positions and try to come to an agreement. If the issues are not resolved in their entirety, the purpose of the Family Management Conference is to assist parties in getting to the next stage. And there can be case management orders made at the family management conference. There can also be conduct orders made at a family management conference, and these typically relate to how the parties should or should not communicate with one another in the interim until that hearing can be held. And so, Erin, if you can go to the next slide, please. So after the family management conference, if not all issues have been resolved, the judge at the family management conference has a couple of options available. They can adjourn the parties to a family case conference, and this is a judge-led mediation, where again, it's a more informal setting, and the goal is to assist the parties in working towards a consent order. Unlike a family management conference, at a family case conference, a judge cannot impose an order except by consent. A judge could also adjourn the parties to a trial preparation conference if the matter is clearly heading towards a hearing or a trial. The trial preparation conference is usually attended just by the lawyers, but if they don't have counsel, the parties will attend, and the judge can make orders about how the trial will proceed, including how and when documents will be exchanged, how evidence will be presented, and general procedures about the trial itself. It may also be that at a family management conference, it's clear what the issue is and the parties are ready to proceed, and the judge can simply adjourn the parties to the judicial case manager to set a trial. And the experience in Victoria since the early resolution prototype started is that parties are coming to their family management conference much more focused with respect to what their issues are. And the trials that are being set are much shorter, and the parties are able to get their hearing dates much faster than they were prior to having that early resolution process. Again, making it more meaningful appearances, less court appearances, and getting parties to a resolution faster, which we all know is better for the families in many respects. And I think, Erin, it's back to you.
Hitting all the buttons I need to come on. So a party can always return to the court for another family management conference. If more than a year has passed since a step was taken in the case and there's no final order, a party can file a notice of intention to proceed and will attend a family management conference to determine the appropriate next steps in their case. If a party has already attended a family management conference and were either adjourned generally or otherwise needed to complete some requirement before returning, and there's been less than a year, or if there's an interim order is needed or an interim order was made at the family management conference that needs to be changed, a party can file the request for scheduling to ask for another family management conference to address that. So it's recognizing that family dynamics do change and that there are times when it makes sense to get back to court or where people take a natural break in their case in order to address other issues for themselves. So in addition to what we've covered with respect to applications about protection orders, priority parenting matters, and family law matters, there are other distinct processes under the rules about the following applications. So there's consent orders about family law matters. These are reviewed as a desk order process. There's an application to be used for these, and that's reviewed by a judge without a court appearance. There's also case management orders. So as we said, those can be made at a family management conference or other court appearance, but there's also distinct applications in order to apply with notice or attendance at a court appearance or by consent, as well as without notice or attendance, again, by desk order. The application for case management order without notice or attendance was something we referenced throughout the processes we just reviewed. So it's used to get permission from the court to modify a requirement or exempt a person from completing a requirement under the rules, including giving less than 7 days notice for an application, proceeding without notice in the case of a priority parenting matter application, filing a reply late or without first meeting the early resolution requirements, and allowing an alternate method of service of an application, among other things. This application is filed with the registry and reviewed by a judge in chambers without the party attending a court appearance. These applications are often reviewed within hours if a timely decision is required, but may take a few days depending on the volume of applications received and the nature of the order sought. Registry staff can assist to provide information about the expected turnaround times in the particular registry. The desk order or any instructions for further information can be returned by email to the party if an email address has been provided with their address for service. We've got the application for an order prohibiting the relocation of a child, which again is the specific to Section 69 of the Family Law Act, where there's already a written agreement or court order in place about parenting arrangements for the child. And then we have applications for enforcement. Where these applications require a court appearance, a party must file the application and serve the other party with at least 7 days notice of the court appearance, similar to the existing notice of motion process. So we'd scheduled a 5-minute break at this point, but I'm the next speaker, so I'm going to carry us forward just because we had some technical difficulties and we'd like to ensure we've got room for questions at the end. So our next segment is about forms. So the new forms use a first-person question and answer format to take a party through the information that needs to be considered when applying for an order about a particular issue. To facilitate this approach, there are more forms under the rules, usually for a narrow set of issues. For example, as we discussed earlier, there's a specific form for applications about protection orders, another form for applications about priority parenting matters, and so on. Some of the forms that are used to apply for orders about many different issues are broken into schedules. A party only needs to complete and file the schedule or schedules that apply to the issue they're asking for an order about. The forms look significantly different under these rules. The approach the Provincial Court Family Rules Working Group took in designing the forms was to make them more conversational, with the goal of the forms being that a party is able to tell their story in a meaningful way and that the court and the other party receive the information they need to guide and inform their decisions. So which form to use? I know this is one of the common questions that are asked with just the sheer volume of new forms under these rules. So the application to obtain an order, application respecting existing orders or agreements, and the consent order package and supporting documents have been replaced with all of these forms listed here. So the family law matter applications and replies provide for both the application to obtain and the application respecting existing orders or agreements. As discussed, the notice to resolve is used to start an action about a family law matter and refers the parties to the early resolution process. There's now a standalone form to reply to a counter application rather than relying on the same reply for the application itself. The consent package has been replaced with the application for a family law matter consent order, where the consent order is specific to a family law matter and must be accompanied by a draft consent order. The financial statement has been replaced under these rules to a more simplified version. Additionally, there are the two new forms under these rules that recognize where family cases may sometimes be paused and need to be restarted. So the notice of intention to proceed and the request for scheduling. These are most commonly used after a family management conference has already occurred with respect to a family law matter, but the notice of intention to proceed can also be used after a notice to resolve has been filed or after an application about a family law matter has been filed and the parties didn't proceed with their family management conference with a year having passed. Lastly, protection orders are no longer on a shared application form. A lot of the feedback contributed to a standalone form and process being developed for these applications. The application provides a streamlined process specific to applications for a protection order or to change or terminate an existing protection order. The form incorporates the application, affidavit, the green sheet or additional information that was required to be filed by the party, as well as the notice of motion from the existing rules. So that's taken 4 existing forms into one. The notice of motion itself is replaced with a series of process-specific forms as well. The forms make an effort to use plain language titles to describe the form and what it's being used for, as well as tracking the terminology from the rules. depending on the required case management order and if the parties are consenting to the order being made, different options are available for the form to use to make those applications. If the application is one that can be made without notice or attendance, such as an application permitting an alternate method of service or waiving or modifying a requirement under the rules, parties are encouraged to use Form I, as these can be reviewed relatively quickly by a judge in chambers without a court appearance. For any other case management order that requires either the consent of the other party or notice to the other party, Form H should be used. The same form is used along with a draft consent order if the application can be reviewed as a desk order application where each party has provided their consent. A court appearance is required, of course, if no draft consent order is provided. The application about a priority parenting matter is used when a court order is needed about the priority parenting matter before any other parenting issues can be addressed or separately from any other parenting issues, usually because something must be done quickly. The application may be made at any time in a case as the situation arises. It's anticipated that this application may be used first to address the priority parenting matter, after which a party will apply for an order about a family law matter to address long-term orders that are required. The application for order prohibiting the relocation of a child is specific to applications under Section 69 of the Family Law Act to prohibit the relocation of a child when there is a written agreement or order about parenting arrangements. If there is no written agreement or order about parenting arrangements, a party can apply under Section 46 of the Family Law Act for an order about changes to a child's residence using either Form M, the application about a priority parenting matter, or Form C, application about a family law matter, depending on the specific circumstances that apply to the change in residence. Lastly, the application about enforcement pulls all the enforcement options from the notice of motion and keeps them together on a purpose-specific application about enforcement. Enforcement under the Family Maintenance Enforcement Act still has its own distinct processes. Where notice is required, a party must be served with a copy of the application at least 7 days before the date of the court appearance. The early resolution requirements do not apply to any of these applications. Additionally, a new written response to application has been introduced under these rules. The form is optional and is to be used in addition to attending the court appearance if a party chooses. Each form is also supported by a guidebook. So a bit of a peek here. So guidebooks were used in Victoria, and they've been modified based on feedback that was received in Victoria. So there's new versions that are rolling out with these new versions of the forms for both Surrey and Victoria. So here's a bit of a sample of what a guidebook looks like. It includes when to use the form and includes a reference to the relevant rule and additional information that a party should be aware of. It also includes steps for completing, filing, and serving the form, in addition to some information about the court appearance itself. And it also includes instructions and tips for completing the different sections of the form. So if it's viewed as a paper form, it will be on the side beside the questions that need to be completed. And if it's viewed in PDF online, you can do the view per page and view two pages on a screen, and it will also be side by side then for a party. So for the forms, fillable PDF forms with supporting guidebooks will be available on the BC Government website December 7th. Paper forms will be available at the Justice Access Centres in both Surrey and Victoria, and at the Surrey Provincial Court and Victoria Law Courts. Other registries will also be able to print the forms as requested for the parties, but they won't have the same booklets available. A web-based application similar to the divorce app is under development for Provincial Court family forms. The first pathway will be for the application about a protection order with a beta targeted for December 7th. So this here is a bit of a sneak peek at the web-based application. So it will be supported on both computers and mobile devices, and will take a user through a series of questions to then generate the required form. Something else that Court Services is working on is the electronic filing for provincial family matters. So part of what the app will integrate is a direct e-filing option when that becomes available. So that concludes our presentation on the Provincial Court family rules specifically. And we're going to move in now to the COVID-19 support variation. Following this component, we will open up the floor for questions. And again, you can continue to put those into the question and answer chat. Thank you.
Okay, so I am here to talk to you about a new process that we have, as well with my colleagues who are part of this as well. This is a new process that we have in government to help parties who have been impacted financially by COVID-19. Just to introduce myself again, I am the Senior Director with Maintenance, Enforcement, and Locate Services, otherwise known as MELS. Take you back to remember March of this year, the early days of the pandemic in BC, and many businesses at that time, they either closed their doors voluntarily or by order of the provincial health officer. This, of course, had quite a significant impact on many BC families, adding to their stress of coping with the global health crisis and closed schools, etc. So as families were dealing with these financial implications, there was a recognition that the ability to pay child support may become a challenge for some. And we know, as was discussed earlier, that child support does not operate in a vacuum. The conflict regarding child support has a direct impact on other aspects of the parenting arrangement. So there was a collaborative effort between various divisions in the Justice Services branch, including the Family Policy Legislative and Transformation Division, the Family Justice Services Division, Maintenance, Enforcement, and Locate Services, Court Services branch, and the Judiciary to anticipate what may be the needs of separated families and what could be implemented quickly to support them. So the result of this collaboration is the early resolution process and expedited court process for those who need to change or suspend child or spousal support, which is a very long name for a practice direction that's referred to in this slide. And this is all for people who are impacted financially by COVID-19. So essentially, the goal is to assist families to reach a resolution outside of court where appropriate. And when this is not possible, and one of the parties determines a court application is necessary, a new service has been introduced to guide applicants and respondents through the application process, and to ensure that parties have the financial documents ready to support their application and response prior to appearing in court. When this is complete, parties are then given an expedited court date, acknowledging the immediate financial impact of COVID. So as parties have received assistance to ensure that their required documentation is ready to present in court, the expectation is this will result in what Judge Wishart referred to earlier as a more meaningful appearance, and ideally reduces the number of court appearances required. Engagement in this process is voluntary. Parties have the option of bypassing it and applying directly to court. However, they will not receive the benefit of an expedited court date or case management of their application by doing this. In this process, parties are required to seek out the services of the Family Justice Services Division or private mediator prior to the case management process. So each stage in the process essentially opens up the door to the next stage. So we're just briefly going over this, and what we'll do now is sort of walk you through the various steps in the process. The first is the early resolution aspect, and Chris Heaney from FJSD will provide some further information on that.
Hi there. Christine Heaney. I'm a program and policy analyst with Family Justice Services in Victoria. So the process for coming to see us, you contact Family Justice Services, and the initiating party would go through our initial needs assessment. And at that point, our staff would determine whether or not the client's eligible for the process. And if they are, they get booked for an appointment with a family justice counselor or a child support officer we have a specialized team of staff who are dealing with these support variation appointments. If the client has issues, but they're not eligible for this expedited process, we would still book them for a regular appointment with our staff if they want to. And in addition to that, if there's already a client who's working with our staff, they didn't come to us through this process, but the staff recognize that they actually might be eligible, they wouldn't have to start at the beginning again because they would have already had their initial needs assessment. But when it's determined that they're eligible and they're interested in the process, that they would then be referred to one of the team members that are a part of this process. Our staff then work with the parties to try and help resolve their support issue and come to an agreement. But if they can't, then our staff complete the bottom portion of the notice of intention or the Form 6. They would provide that to the client, and then the client can then move on with the process. So as of Friday of last week, we have seen 79 different files since July the 2nd. As far as what we're seeing at Family Justice Services, our staff are finding actually that there's a large number of second parties who are saying that they're just not interested in going through the process. And that staff are finding that they're sometimes unable to contact the second party. And so those files don't then proceed. And we've also seen a number of clients who have more than just support issues to sort through. So going through this process is it's looking just at child or spousal support. So if they have additional issues, then they would go on and work with a family justice counselor to deal with those. Sometimes clients already have a court date set, and then they decide to stick with that when they can't agree. Or when they have more than just support issues, sometimes they're choosing to wait for a court date so that they can resolve all of them at the same time. The good news is, though, that we've had 5 agreements signed since we started, and we have several files that are still in ongoing mediation. And so now over to Sandra to explain what happens when the clients can't agree and want to move on in the process.
Okay, thanks, Chris. So when parties have moved through FJSD and still have not resolved their issues, they move into something called the pre-court case management process. And this process is a new program. Basically, it's available. It is housed at the Maintenance Enforcement and Locate Services. And basically what we do here is we assist parties to make sure that they have all the documentation that they needed, that they're going to need to pursue the matter in court, and answer their questions in terms of the process. In order to receive service here, you need to have the notice of intention that has been signed, completed by the parties and then signed at Family Justice Services Division. And that way we know that they have gone through that process and have not been successful, either because it's out of scope or for one of the reasons that Chris mentioned. Some of the new documents that are required in this service there is a financial addendum. So parties still need to complete the financial statement that they typically do when they're making an application to court. But this document has more specific information for them around what's been the impact of COVID-19 on their income. They also complete the standard financial statement, as I said, and an application to obtain an order. So once we've completed this, where we've assisted the applicant to get everything in order, we then file the application on their behalf with the court registry, and then instruct the applicant on how they need to serve the respondent. The respondent will be given information in their package on how to contact PCCM, and so that we can assist them as well. The respondent has 30 days to reply, and so either the reply has been received and it's sent to PCCM, or the 30 days has expired and PCCM will then reach out to a judicial case manager to start the process of scheduling a court date. One additional piece that we have in this process is we have amicus curiae, which is a friend of the court. So it is a lawyer who is assigned on file and will be assigned on the more complicated cases, and they are there to assist the judiciary. So they don't represent either party, but they provide information to sort of assist the judge if needed, and ideally, again, assist in order to expedite the whole court process. The early resolution project is referred to earlier as well as Rule 5 registries. They have a slightly different process. It's basically just different forms, and we will assist with those as well. So I'm going to pass it on now to Judge Wishart to talk about the court process.
Thank you, Sandra. So the expedited court process is quite straightforward, and we really benefit from the work that happens at the front end, because by the time the matter gets to court, the parties already have all of their documents together, and so we don't need to adjourn multiple times waiting for that to happen, or waiting for people to get legal advice or other assistance. When they're ready to schedule their court hearing, they are immediately scheduled for that one hearing appearance, and as Sandra mentioned, it's scheduled through the judicial case manager. So again, we're scheduling it with the parties' availability, and so they just come to court once for that hearing, and a decision is often able to be made either right there and then at the end of that hearing, or within a matter of days if the judge reserves. So the expedited part of the court process is the fact that people just have one court hearing scheduled with their availability, and we're able to schedule those relatively quickly once the pleadings are complete. We've tried a new process with respect to these matters, which is a more centralized scheduling. So if it's a matter from a smaller location where there might not be court every day, we're able to take advantage of resources in other locations. Because all of these are being heard by video or telephone, we don't need a physical courtroom for people to attend. And that really increases the access to justice. Part of this, where people don't have to travel long distances, don't have to take time off work for an entire day, and they know that when their hearing is scheduled, it will proceed and conclude that day, even if a decision might be a few days down the road. So again, the court benefits from all of the work that's done in the front end process to assist the parties in narrowing the issues and making sure that they have all of their financial materials ready for their court hearing. As a result of very recent improvements in technology, judges are able to access the court file completely electronically. So they're able to see all of the financial information that's been filed, and the addition of amicus on those more complicated files, again, just ensures that matter can proceed when it's scheduled without needing an adjournment, and that the hearing can proceed on that date. And Sandra, I'll turn it back to you in terms of what's next.
Thank you. So there's this program sort of started in government terms at breakneck speed, and that it was, the discussion started in the spring, and it was implemented in the summer. So the funding for this was for 6 months. The new sort of aspect of it is the PCCM. FJSD, is delivering service as they always have, and with some added features for this program, and the courts as well. But we have funding for PCCM for 6 months, and we're basically more than likely till end of fiscal. So there will be a review of the program in January, and there are lots of variables to consider. First, of course, we're in the midst of a second wave, and there's lots of unknowns as in terms of what kinds of closures or the financial impact the new financial impact that people will be experiencing, as well as the impact of the first wave, of course, has long-term implications for many families. We have not had a lot of applications go through PCCM and move on their way to court. And the reasons for this could be many. Part of it is, of course, that we're actually, I think the goal really is for people to be able to reach resolution through JSD. As you heard from Chris, there have been many files that have moved through that process. So that's ideal. It may also be that people have not yet found their way to this process as it is new. And it may also be that there is not a significant need for it. And that's something will still be determined. So at this point, to say it's still up in the air whether we will continue to have this service, after this fiscal. But for now, at least, I would encourage you to inform those you're assisting of the program if they are financially impacted by COVID, and they can always just reach out to PCCM as well, just for questions, and we can guide them as to how they sort of go through the process. And that's. I think that's all we've got on this. And so I think we're moving on to the question aspect.
Thanks, Sandra. So thank you everyone for joining us today and providing us this opportunity to share these family law developments in provincial court with you. I'd like to invite the panelists to turn on their videos. And I will stop screen sharing in just a moment and we can open up for questions. So again, just use the question and answer option there on your side panel to type in your questions and we'll work our way through those. If we don't have time to get to all your questions that are provided in the chat, we will provide you with a response after we've concluded for today. You can also send any questions you may have to the email address on your screen. So about the processes we've covered here today, and we'll ensure we get those questions forwarded to the appropriate panelist for response. So I'm going to stop sharing so we can hopefully all see each other a bit larger. Okay, so just looking through the questions that we've received so far, we do have a request, first of all, to get a copy of the intake sheet or questionnaire that Oriole was talking about for Family Justice Services Division. Oriole, is that something you're able to share with this group?
So typically we don't share the questionnaire very broadly. And I will also say it's under review at the moment. We're taking another look at the tool itself with sort of through the lens of new research and trauma-informed practice to ensure that we're, taking the most current approach to assessing for these things. But I can appreciate the question in terms of being able to best provide information and prepare your clients who are coming in. So in the absence of me sharing the form directly at the moment, I can maybe give you a little bit of information and that might help with preparing folks. So as our assessment tool for your information is actually 3 parts. So the first part is the questionnaire that goes to clients. A second part is more for the family justice counselors that are using the tool that provides a lot of information and probing questions that they delve into once they're meeting one-on-one with the parties. And finally, a scoring guide that's used in some cases, particularly to identify sort of those the cases that are higher risk or more likely to be not appropriate for mediation. So the questionnaire itself, so if you're giving information to your clients, they'll be provided ahead of time. And if it's in office, they come early and they can sit down with the form. They can bring someone with them if they think that would be helpful for them in terms of completing the form in the office, but otherwise it's provided electronically to them. It's 22 questions. And so it just is an initial snapshot that allows the family justice counselor then to get into some of the dynamics that it discusses. And so the questions are grouped together sort of in subject matter. So it starts off with sort of levels of conflict. So maybe about like how well they and the other person talk to each other about the kids, and it has a range from sort of really well to very poorly. And there's also an option there for them to tick if they don't want to write it on the form and they prefer to discuss it directly with the family justice counselor. There's questions around finances and debt. So, how well do they expect that they and the other party will be able to make decisions about separating their joint finances if it's a newer separation, or addressing child or spousal support related issues in financial conversations. The pieces around substance and use and mental health, particularly those questions focus on asking them about themselves and the other party, the influence of mental health or substance abuse on their parenting specifically, because it's about those matters. Family violence questions then are quite direct. So they're very behavioral focused specific questions about various aspects of family violence. And so when we're giving clients a heads up that we're going to be sending them this form, or that they're coming in for an assessment interview, we're really taking a trauma-informed approach to how that's being done, to really respect those principles of providing early information and choice. And so making sure clients know that the questionnaire is quite personal. For some folks, it might be upsetting. And so we want to let them know ahead of time so that they're not surprised when they're answering, when they're looking at the form. And that if they feel like they might be triggered, that it might be useful to have some support set up for them, either while they're completing the form at home or during the assessment interview itself. So I'm not sure if that helps in terms of messaging to the clients that you might be working with, but hopefully that provides you a little bit more insight. And really, it's a one-on-one appointment with a counselor who can give information to help them identify their issues. So part of it is assessing for some of those things and the appropriateness of CDR, but really it's about an opportunity to talk about their families and what they're looking for and what might be useful for them moving forward.
Thanks, Oriole. So the next question is also something hopefully you'll be able to answer. So it's around, I don't understand what you were saying. Were you saying that the family justice counselor could decide that there is some sort of accommodation, like shuttle mediation, that would mitigate family violence or power imbalance in the relationship, and that the very presence of those things does not automatically make someone exempt from CDR?
That's a really great question, and happy to clarify. So a little bit of both. So family justice counselors and all consensual dispute resolution professionals, have training in how to assess for and potentially manage issues around safety and power imbalances through a dispute resolution process. And so the existence of one of those dynamics or some of those dynamics doesn't necessarily preclude them from the CDR requirement. So it really is circumstance dependent. So depending on the considerations for each situation. So for example, if there was an incident at the time of separation 10 years ago, no other indications of power imbalances, and they've been co-parenting quite successfully for some time, that circumstance is going to look a lot different than a family where there's been recent and significant violence and ongoing coercive control issues that are very unlikely to be mitigated, to make a process safe and to have parties being in a position where they're able to kind of negotiate a fair agreement. So the assessment process and ongoing assessment and support to the parties there's an opportunity to look at whether a process can be designed that would meet those needs. But in the event that folks aren't able to be negotiating that fair agreement, or the control issues are not able to be mitigated, then absolutely they would be given that exemption and they wouldn't have to meet that requirement and they could move forward. Hopefully that answers your question.
Thanks, Oriole. So the next question that we've got here is, I thought it was 21 days to file a reply to account for the time taken in the ERP at the beginning. So you're not incorrect with that. So with Victoria, so as Shannon described, we've got a few different rules that are going on right now. We have the prototype that has been operating in Victoria since 2019. And then we have the early resolution and case management model that is rolling out here in December to Surrey and Victoria, as well as the broader Provincial Court family rules implementation that is happening in May. So Victoria provided us with a really great opportunity to prototype these rules and the model. And as part of that prototype, we tried having 21 days to file the reply, specifically taking into account the time that happens at the early resolution process in the beginning and the fact that the second party would likely be engaged and be able to start doing some of the prep to file the reply. With the broader rollout of the Provincial Court family rules, those rules that apply to filing the reply and the 30-day period would apply across the board, regardless of whether a registry is an early resolution registry or not. And a decision was made that rather than having different standards or reply periods depending on the type of registry you were filing in, that it made more sense for it to be a consistent time period for everywhere in the province, recognizing that sometimes a family may live in two different jurisdictions, one in which there is the early resolution model and one in which there isn't. So we didn't want to risk parties being late filing a reply because they thought it was 21 days instead of 30, or being unable to complete all the requirements in terms of financial disclosure if they were in a registry where they had not had that early resolution benefit, and it was set at 21 days. So again, hopefully that answers that question. Again, it is 21 days at this time in Victoria, and that will shift back to 30 days. So the next question that we have here is, you said that there have been client surveys expressing satisfaction with the Victoria pilot. Will this research be publicly available? Oriole, do you want to respond to that one?
Sure. Yeah, so sort of those observations are sort of the early client surveys, and we're continuing with collecting data and contacting clients that have been through the early resolution process as well. Now that there's been some time, we're going to be seeing clients that have moved through the court process as well. So we're hoping by early next year we'll have a formal final evaluation report, and when that becomes available, then we'll be able to share it with others who might be interested.
Thanks, Oriole. So that concludes the answers that we had waiting. Oh, it looks like we've got one more that's just come in here. Okay, so would not wanting to participate in CDR be enough to exempt someone from CDR? Or will FJCs make people do it anyway before allowing them to make their court application? So Oriole, I can address that in terms of the requirements. So not wanting to participate is generally not enough to exempt someone. So if someone simply does not want to, they could make an application to the court to be exempt, though I'm not certain the court would grant such an application. So maybe Oriole, in terms of the process of the conversation that you may have with clients as you're approaching that, because of course if party two doesn't choose to, that can be a bit of a different story, or one of the two parties. So Oriole, anything to add around what that process looks like with Family Justice Services Division?
Yeah, I mean, I think the whole purpose of the assessment interview and ongoing conversations is to really get to the heart of what's going on for folks. And as you mentioned, the rule is very clear that if someone says they're just not interested, that doesn't meet the sort of threshold for exception, but there is that room for the decision around it not being appropriate. And that really comes down to the information that's shared with the Family Justice Counselor. So for folks who are working with clients where they have information around, say, family violence, encouraging them to share that with the Family Justice Counselor so that an appropriate decision can be made, I think is really useful, because the Family Justice Counselors can only make decisions, just as a court could, based on the information that they have available to them. And there is confidentiality in the process, and so we're very mindful of not sharing information, and where there are safety issues, being mindful of how that's messaged back and forth between the parties. But I'm going to actually pass it maybe over to Judge Wishart if you want to explain a little bit about sort of how the court views that requirement.
Thanks, Oriole. We do see applications from people to be exempt from the front-end process, saying they're not interested in mediation, and without more, I would likely deny that application. We find that once people actually get into the early resolution process, they do find it quite helpful. If the application is made because the parties tried mediation 2 months ago and that was not successful, then I'm much more likely to grant that application. And so it really depends on why somebody says they don't want to participate in the mediation. And we do find at the family management conferences that if there hasn't been that engagement by both parties and there hasn't been a mediation with the assistance of counsel or duty counsel, we might actually adjourn the family management conference so that the parties can go back and try mediation. Because once they get a little bit more information, a little bit more understanding about how the process works and what's possible, parties tend to be a little more keen on trying mediation. So it's definitely situation specific, but I think a blanket statement that I'm not interested in mediation is unlikely to result in somebody being exempt from that front end process.
Thanks, Judge Wishart. And I think just to add to that, a lot of the applications for exemption that we have been seeing in Victoria are actually usually for some of the reasons that the FJC would exempt a party anyways, such as having tried CDR within a couple months, or it not being appropriate because of family violence or power imbalances or other such things. So sometimes being able to have the party go through that needs assessment before they make the decision to ask for an application for exemption from the court is frequently beneficial, just because there are other resources and supports and referrals and assistance that's provided by FJSD through that needs assessment. So that's something that we're certainly encouraging is before jumping to that application for exemption to consider whether or not it would already be inappropriate through that process with FJSD. So the next question we have is around family justice counselors being gatekeepers of the court and how it aligns with the principles of access to justice. So I'm actually wondering, Judge Wishart, if you might be able to speak to the role that the court sees family justice services having with relation to access to justice for parties.
Certainly, thank you, Erin. That's a fantastic question. And although I was not involved in the new rules from the beginning, I know that it was very important for all of the stakeholders that this early resolution process is seen as part of the court process. So it's not seen as a completely separate avenue from the courts. It's part of the court process, and there is still a path for people to get to court. Certainly if it's an urgent matter, whether it's a protection order or one of the priority parenting applications, people can get into court the same day if needed. And so that access is still there. And in my view, these rules provide people greater access to information and legal advice much earlier on in the process than what we currently have everywhere but Victoria, which is if people have a family problem, all that they know to do is to come to court and start a legal action, whereas that is usually the least effective way to solve a family problem. So by including that early resolution part into the court process, by providing that early information and legal advice, I think it actually increases people's access to justice, where they are able to resolve their problems much earlier. And if not, they are able to get into court fairly easily. Now, I appreciate that early resolution part, if it's not an urgent matter, it can take some time. But when we looked at the time that takes and added on how long it would take to schedule a family management conference if they do need to come to court, it is either the same or a little bit faster to get to a meaningful court appearance under the new early resolution process. When you look at starting with the Justice Access Center and getting to a family management conference where something meaningful happens, that is still a faster process than what we currently have with more meaningful outcomes. So I hope that answers that question.
Thanks, Judge Wishart. Shannon, do you have anything to add to that, just around the access to justice piece with the development of the rules?
No, I think Judge Wishart gave a really comprehensive answer. I think the only thing that I would add is that when I looked at the question and the comments sort of comparing family justice counselors as gatekeepers to the court, it's not the family justice counselor's role to sort of decide what the exemptions are. The exemptions are set out in the rules. So the family justice counselor's job is simply to apply the rules to individual circumstances.
Thanks, Shannon. So again, we have no other questions in the queue right now. Anyone's?
Looks like that's pretty well it. And we finished just 10 minutes beforehand. So thank you to the speakers. Thank you to all of you for coming and making time in your schedules to do this presentation. It's great for the advocates to have this information so they know what's coming and all the processes that affect their clients. I guess if people have other questions, there is the contact information in the PowerPoint. And I think that's it. There's thank yous coming in from some of the people. So thank you very much. Bye.
Thanks again for having us.